Padma Shri Dr. Mohan, Mr. Srinivasan K. Swami, Sri C. Velan, Mr. Vijay Bhaskar Reddy, my good friend Professor Vanangamudi, Mr. DHANAPAL, distinguished guests, ladies and gentlemen, a fine good morning to you all. This concept of company law has always baffled me. I was always a criminal trial lawyer, and I was always involved in individuals committing offences. But when you think about this concept of company law, what immediately comes to my mind is the East India Company. East India Company, of course you all may be aware, was governor and merchant company of merchants of London. It's called Governor and Merchants of Company of London. Company of Merchants of London, I'm sorry. Governor and Company of Merchants of London. It's a group of people there. In 1600, they all pulled in their money because Vasco da Gama showed them the route that you go to India, you can make a lot of money. So everybody invested. Parliamentary people went and told Elizabeth, come on, you please give us a charter, we'll go and make money and come. And East India Company was formed to do business here. And within 100 years, we told East India Company, please don't do business. You take over the administration, we'll give you all the money, we said. And one fine day, they found all the barons and lords who had invested money and become totally rich. Very rich they became. Warren Hastings started making money. Lord Clive started making money. Everybody started making money. So naturally, you see, it attracts the eye of those who were not able to make money, and Edmund Burke was one of them who said, put an end to all these fellows. These fellows are making a lot of money. Because government had no control over the company. The Elizabeth Queen, she did not have the control over the company because it was a private enterprise. So the first time what they do is Pitt's India Act 1784 was passed. I think I would always think that this Pitt's India Act is the precursor for all this company law, because for the first time the British Parliament said there should be a state intervention in affairs of a private company. And from then on, you see, the East India Company was totally dissolved. It was dissolved because it became very obvious that they were asked to do business, but they started controlling and taking administrative powers. So East India Company was dissolved, 1850 mutiny takes place, and then the Queen takes over. Now what I used to think is the concept of a juristic person in the company law. The concept of juristic person. The juristic person is that, yes, I am not a natural person, but here is a juristic person which can do business, which can do offense, which can be made liable. So the Indian Penal Code describes a person as a collection of individuals. It also takes into consideration a juristic person. So this is the evolution of the company law, where juristic persons as an individual comes to be accepted in the eye of law. Now, let us, if you go a little thing. Dr. Mohan was saying, why at all I was being called? Yes, Dr. Mohan, I'll give you the answer. If you read this 2013 Companies Act section 447, which prescribes the penalty, anybody will get diabetes. Anybody will get diabetes. Because hitherto, it was the concept of, I am not in charge of this, it was the company which is doing, so I can wriggle out and come. That regime is shifting. I had the occasion as a lawyer to defend one of the accused in the infamous Satyam scandal. Oh. I was engaged by one of them who thought that he was one of the number 8 in the hierarchy of Ramalinga Raju and the brother Ramalinga, and I was privy to, I would not like to disclose all that because that is history now. The problem there was professionals had connived with businessmen in creating a smoke screen, and the money was trained. Beyond this, I really don't want to share with you anything because so many things were told, informed to me in the thing, and the confession given by Ramalinga Raju overnight when he says that yes, this is exactly what I did, and why Ramalinga Raju gave the confession, we know about it, who are the other players behind it, and all that, that's something different. But coming back to this company law of 2013, as I told you, earlier act also baffled us very much because Ramaya used to be our guide. Ramaya used to be the Bible or Bhagavad Gita or Quran or whatever you call. Now 2013 Act comes, and when you go through the 2013 Act, you find that the company secretaries are going to be brought into the net. And that because the word key managerial position which has been defined in the 2013 Act is also making the company secretaries personally responsible and liable for offences. So a sense of professionalism has to be brought into this country. The sense of professionalism is that we must be professional in advising and aiding our clients. This is an era where professionalism, because those were the eras when people were appointed because, after all, he is my uncle's son, I'll put him here. He is my aunt's son. My wife gave a recommendation, put this fellow here. Those sorts of appointments can never be done now because the law says that this is exactly what. Otherwise, your uncle's son will go to jail. He will also go along with you to jail. This is the extent of which the act has been amended. So today, the corporate governance would expect professional company secretaries who are well versed in this company law and who are going to really advise the funding people. Yet another thing which really baffled me is that one-man company was hitherto unknown to us. We knew only 2 persons only can join a company. Now a situation arises that this act recognizes that there could be a one-man company, which means that yes, you can start it and you can. That also reflects one thing, that we are not now able to join together with any person and properly conduct business. We have become so terribly independent or so terribly greedy or so terribly avaricious that no, all profits are mine. It will be a one-man company, so I take it or I fall. Very good. Law says, after all, you want to do this, I will provide a provision for you. We have a one-man company. So one-man company has come to stay. And one-man company is something which we have to grapple with in understanding the liability of an individual vis-a-vis the company. Now coming to Mr. DHANAPAL's work, everyone had waxed eloquent about his work, and I have more to add. One thing is that, as I told you, this company law had really baffled me, and recently I had an occasion to deal with this company law. While discussing the section 73, which Mr. Swami was saying about receipt of deposits from public. This was one thing which was raging in my court. The question was that whether a company which accepts deposits from public, can those companies be prosecuted under the Tamil Nadu Protection of Investment of Depositors Act, which prescribes a punishment of 5 years, 10 years, etc., etc., for the default of the company in repaying the deposits, or should the person go only under section 74 of the Act, the mechanism provided for, etc. was a raging controversy which came to my court. Well, there are two views in that, my dear friend, two views in that. One view is that yes, there are companies which are into the business of finance, with the principal business is finance. So the state's argument was, the company law 2013 can exist along with the Tamil Nadu Act, and if a company is going to default in repaying the deposit, it has to go to jail. The people who have to go to jail were responsible for it. That was one extreme argument. The other extreme argument was, if you are going to do all that, then every Tom, Dick and Harry, every small company which had nothing to do with finance, but which takes deposits only to plow into its business. A small company or a big company, whatever it is, they are not into thing, but their interest rates are governed by the Act and the rules frame. They cannot charge a fancy interest because that TINPID Act was brought into force to catch hold of people who were charging fancy interest. So this was an argument quite convincing. I had to put a very center road. I had to put a very, I had to take a very center road in this deciding this issue, and I held that, well, a company, if it is going to take deposits from public for the purpose of its business, and that it is not into the business of finance. If it is going to be the business of manufacturing, it is going to be the business of jaggery trading or any other trading, and for that purpose, if it is going to take money and fails to repay the amount, then they cannot be brought into the net of the Tamped Act, because I really felt that police powers should not be given to that extent so as to stifle honest business in this country. So when I was doing this research, I had an occasion to go to the Tamil Nadu archives to sit and read several of the old things. You know, my dear friends, I was so surprised to find that the East India Company's book records of executing Veerapandi Kattabomman. I had to do research there. I went to Tamil Nadu archives personally, sat there with the commissioner, and I was given all the papers. So they showed me records of how East India Company had conducted an inquiry about Kattabomman, and the entire record of the company servants writing it in parchment. The book is so big, it's available there. If anyone could go and see, they have beautifully done it, and it's in English. Of course, it's in Victorian English, where you'll have to use a little amount of your own thing and decipher it. And how the company executes. Of course, that would have provided the grist for Jawar Sitaraman to write the dialogues for it, and for Shivaji Ganesan to give more melodrama, more thing into it. That's a different issue. So company and its activities and maintaining of registers is there, has been there, and these registers are now perhaps being translated into statutory registers by our Companies Act. So here again, as I was telling you, this concept of the company receiving deposits and company not refunding deposit is still a grey area, and I'm just waiting for a judgment of the Supreme Court whether they're going to reverse my judgment or they're going to accept my thing. It's $1 million question. I was also discussing this with DHANAPAL very recently. The moment DHANAPAL sent me this book for reading and review, I just asked myself a question. I am not technically savvy. I am not very computer savvy. I still rely on this black and white hardbound books for my research. And of course, today, when we have everything in net, it's indeed a great endeavor for DHANAPAL to come out with this hardbound book, expecting people to go through it. And I'm sure this will have a great welcome, because anytime we may have a power cut and power off, net and all will fail. DHANAPAL's book will have to come to a rescue wherever we are. Of course, that's not the only reason. Yet another reason is, you go into Google, the search is so beautiful, you put in the search, then immediately answer comes to you. I tell you, my dear friends, DHANAPAL's book is typically like that. Because I did not have time to go through this entire volume. I had to speak here. So first thing I thought was, alright, which is a topic which is dear to me? Fraud is a topic that is dear to me, because all along my career I had been a lawyer for frauds. So the moment I just opened, I had no clue about it. Like going to search engine, I just opened it, I found enforcement and prosecution mechanism, fraud, page number 420. Page number 420. I don't know whether it was sheer accident or contrived or whatever it is. I'm not joking. Please take the contents. I'll separate it to you. Page number 420 comes this subject of fraud. So DHANAPAL, there is so much of sense of appropriateness in you that even when you choose the page numbers, you choose the correct topics, my dear friend. So I congratulate you for this, and I really hope that. And when I went through this chapter, I really had a great light about section 447 and implications of section 447, etc., etc., and what havoc it is going to create in the future, or whether it is going to put us all in proper thing and make us more professional. The concept of professionalism, I always used to feel that when Duryodhana goes and approaches that Pandava brothers and asks them, when there is a time to start the war, you start the war on this time, you will succeed. This is the amount of professionalism we had. Even when you know that that fellow is going to be our adversary, he is our adversary. And when he comes and asks this Nagula fellow, or Sakadev, which of the two fellows, I don't know, he comes and asks them, what is the time to start the war? He said, you start the war on Amavasa day, this is the day, you will succeed. So all these Arjuna and all, why did you give him the time to start the war? He said, he came and consulted me as a professional. I told him the truth. I cannot hide, he said. And once again, the maverick Sri Krishna had to interfere and create a new Amavasa for the thing to think. So my dear friends, we are now in an age of absolute professionalism, and I am sure that Dhanapalan's book will be of very great use to everyone for the simple reason it's catalog, it's easy search engine, for search engine I would call it, because it practically when you open it, subject-wise he has dealt with, and subject-wise he has dealt with in simple language for any layman to understand, and I really hope that he comes up with, because as they pointed out, this book will become obsolete the next year, and by time I think Dhanapalan will have to start again. It's a great thing. Challenges are that we had Nabi, we had taxmen, and now we are going to have Sridhanya Foundation is going to be a parallel to Nabi and taxmen, and I really wish them that they show that in South India also we can provide such easy search engines for physical books. With this, I congratulate Mr. Dhanapalan for this book, and I pray that he comes up more and more with such endeavors. Thank you.